okay, better than any other places. But we usually organize, luncheon seminars on the peace and security, allocate U.S. relations, inter-Korean relations, kind of things. But it's very rare for us. You may know Bini Agarwal, and Bini came here and gave a talk twice. But that's a trade issue. TPP versus RCEP. But this kind of intellectual property right is very, very rare here, and that's why I think that we have a bit lesser attendance here, but it is my really great pleasure to introduce Carl, because he's really leading scholars in intellectual property right and territoriality. That is why you can raise questions on territorial dispute in South China Sea and East China Sea during the Q&A session. Okay, but here, you can see they are either diplomats, reporters, and international UN organization officials and university professors. Professor Sang Young-Yu, he's the managing director of this foundation, Professor Yu, and Professor Lee, he's a leading expert on Korea-Australian economic relations. He used to teach at, you taught at what, the
Melbourne University.
Melbourne University. And then he came over here and he joined the Yonsei University. And also, we have a lot of bright grad students who might be interested in your law school. Okay, but Carl came to Seoul to recruit some students, and to encourage those who admitted UCLA Law School, and trying to recruit the future prospective students. And with this one, let us give big applause to Carl.
Well, thank you so much for having me. I appreciate coming out here, and I should say I've taught at Melbourne myself, and I'm a fan of that, and work quite a bit with the Australian government, so I'm happy to discuss. As Professor Moon mentioned, I'm going to talk about intellectual property, but in the Q&A portion, I'm going to stand if that's okay. In the Q&A portion, I'm happy to discuss other topics, general foreign policy issues, et cetera, that might come up, so feel free to ask whatever you like. Today, what I will do is talk about the role of high technology in the global economy. And I picked two examples, both of which are timely issues right now. So first, Apple versus Samsung. I think here in Korea, I don't need to explain why this is a big dispute. These two companies are giants in the telecom world, mobile phones, other forms of electronics, and they have been battling each other for years now at very high stakes, with billions of dollars at stake and a lot of market share at stake. The U.S. Supreme Court just granted review of a decision in the U.S. strongly implicating this struggle between the two companies. So I'm going to talk about that a little bit first and what it means. But then second, I want to talk about ICANN, the Internet Corporation for Assigned Names and Numbers. So if you are familiar with ICANN, you know it's quite important. If you're not, you use ICANN every day. Because ICANN is what makes sure that when you type in a website, if you want to put in UCLA Law School, that you actually get to that website, and that you can purchase and sustain a particular domain name on the internet. So ICANN is a critical part of internet governance, and just last month, a very important decision about the future of internet governance was made in Marrakesh, which I will talk about in a moment. So both of these things are things that are in the news right now, and I'm going to kind of link them together and give you a brief overview of how they relate to bigger issues in the world economy. So let me start with Apple versus Samsung. Again, two gigantic companies. ICANN I'll come to at the end. Just in terms of intellectual property, to step back, the connecting line between these two cases, I think here, especially in Korea, we can see the power of intellectual property to drive an advanced economy. So the Korean economy is one of the most powerful in the world today. That was not true 50 years ago, was not true 30 years ago. One of the reasons Korea has had such fantastic economic growth and has been so successful is it has harnessed intellectual property and high technology industries to grow. And that's not unique to Korea. Korea just happens to be an exemplar. The same is true in the United States, in Europe, elsewhere in Asia. These issues, of course, are contentious. So I note there have been 42 IP-related disputes at the World Trade Organization, either settled or pending. So intellectual property is a high-stakes issue right now. We were talking a moment ago about TPP, Trans-Pacific Partnership. intellectual property is a significant part of the TPP as we now have it. It's, of course, also a very significant part of the World Trade Organization rules when the WTO was created, and really it's essential to almost every major trade agreement today. The IP rules are critical. For the US economy, we might be looking at as much as $1 trillion in exports annually that are IP sensitive or dependent. We have a representative from Finland. The Finnish economy is very IP dependent. I mean, for any modern industrial economy, IP is critical. I note Korea, fourth in patents granted, so very active. So the issue of controlling IP, who controls intellectual production and the expression of those ideas, whether technological or otherwise. I'm going to focus more on things that are patent related today, but obviously copyright is equally important. So IP is increasingly significant. Okay, so Apple v. Samsung. Let me just give a quick overview. So these two giants have been battling for years. There have been over 50 lawsuits in over 20 jurisdictions around the world. The most important jurisdictions are the US and Korea, the US being the biggest market. This has been a very important and very costly legal battle. The suits began in 2011. Apple sues Samsung, and I'll talk more about exactly about what. In April 2012, in a courtroom in San Jose, presided over by Judge Lucy Koh, Apple was awarded a $1 billion judgment. This is a big judgment. In August 2014, and that was just one of several different disputes in US courts. August 2014, Apple and Samsung decide that they're going to bury the hatchet. They're going to end all of their disputes around the world, settle all non-US litigation, but they're going to continue in the United States. And again, nearly 20 jurisdictions were involved. So they settled all of those disputes, but the US ones kept going because those are the most valuable. May 2015, so about a year ago, what's called the Federal Circuit, which is just below the Supreme Court and handles specialized areas, most importantly intellectual property. The Federal Circuit Court upheld an award to Apple for two issues, and I'm going to talk about these: design patents and trade dress, and I'll explain what those both mean. Samsung fought back against that, sought review by the Supreme Court, and last month, the Supreme Court agreed to review on a narrow question, but a very important one, which is if Samsung is in fact infringing on the patents that Apple has, how much money can it get? Can it get all of the profits from Samsung's putatively infringing sales, or just a portion? However, in the review, when Samsung sought review, they sought review on a broader set of issues, and I'll talk about those broader set of issues. I'll note, for design patents, this is the first time the Supreme Court has considered a design patent case in over 100 years. So just as a legal question, this is quite interesting, but of course it has great implications for the future of both companies and also for how we think about innovation in a global economy. Okay, so just to give you an example. Now, I want to say up front, these pictures, this image, and I realize it's a little bit fuzzy, I actually took this out of Apple's brief to the Supreme Court. So I'm not going to claim that this is 100% accurate, but I believe it's accurate. These are examples of Samsung products before the introduction of the iPhone. The iPhone first came out in 2007. I'm just curious, how many people here are iPhone users? How many people here have an iPhone in their pocket right now? Okay. How many people have a Samsung phone? Okay, interesting, even in Korea. Samsung products are great. I happen to be an iPhone user myself. Okay, so these are pre-iPhone Samsung handsets. 2007, the mobile phone industry is still pretty large. Not as large as it is today, but pretty large. You can see a progression. Most phones of this era look this way. So if you, Palm, which really doesn't exist anymore, had the Palm Pilot and then the Trio, which was their version. The Trio looked almost exactly like this. That was the typical way. You can see right before, that's the Blackjack phone, that's Samsung's Blackjack phone. Right before the introduction of the iPhone, there's a move away from antennas that stick out, trying to have a sleeker design. Of course, many phones of this era still were flip phones. This was a time when Motorola was a significant player, Nokia, others. But you're starting to see this style of phone. And then the iPhone comes in, And it does change the marketplace quite dramatically. So one of the points that Apple makes is if you look at Samsung's design, let's just look purely visual, put aside the technology, just visual. After the iPhone, Samsung phones begin to look a lot like the iPhone. Galaxy 5, etc., etc. And I think it's fair to say that they do. They do look a lot like the iPhone. The interesting question, and the really important one for us, is that a problem? Because, of course, in a world economy that's competitive, an open market, what we want to see is competition between companies that will produce the best products at the lowest price for us as consumers. That's what we seek. That's the purpose of the TPP. That's the purpose of really any open market economy like the one we're in right now. But intellectual property exists to make sure that that kind of competition is at times restrained so that innovation can be furthered. The theory being that if you can copy either the technology behind a phone, the look and feel of a phone, the mark of a phone, or any product really, so patent, copyright, and trademark, if you can copy those features, and if an innovator knows they will be copied, they will not invest in the initial innovation, and that will ultimately drive out important innovation. So we have a delicate balance between competition on the one hand and fostering innovation on the other. And this case tees that up very clearly. So yes, these phones look a lot like the iPhone. However, it's hard to say if that's a good thing or a bad thing, and we'll get to whether it's a good or bad thing, but that's the key question. Is it a problem or is it not a problem? Okay, this is 2007. These are quarterly kind of market share issues, and you can see when the Galaxy S comes in 2010, Samsung has a pretty big boost. So these phones are very successful for Samsung, very successful. So again, whether copied or not, they do well in the marketplace. Consumers like Samsung products, despite the survey we just had in this room. Samsung actually has larger market share than Apple worldwide. Okay, the two companies fought each other and sued each other back and forth. I'm going to focus more on what Apple claimed than what Samsung claimed because that's what's at stake right now in the litigation in the United States. But you can note over here on this side that Samsung alleged that Apple had infringed a number of important patents about the construction of a phone. And one thing to bear in mind, just take a guess, how many patents do you think are embedded in a single phone? Samsung or iPhone, it doesn't really matter, Apple. How many patents do you think are in a single phone?
500.
Good guess, a little low.
I was
Anyone
thinking
else?
higher too.
2000s.
Getting warmer. We'll put those two together. 250,000 patents are at stake in a handheld computer like this. That's a rough number. Obviously, every particular phone will have a different number of patents, and it's really an estimate. But there are so many aspects of innovation embedded in a phone. A phone is such a complicated piece of technology and so valuable that the number of patents is really extraordinary. So just bear in mind when we talk about one patent being infringed by one company and another being infringed by another company, this is a tiny slice of the intellectual infrastructure in the phone market. Okay, so Apple versus Samsung. Samsung claimed a series of things. Let's talk about what Apple claimed. I want to talk about one in particular. If you can see on the upper left, patents, these are shorthand, 087677. The ornamental design of the iPhone. So one of the things that Apple claimed is that if you look at the rounded corner shape, Samsung, first of all, copied that in Apple's view. And second of all, Apple claimed what's called a design patent on that shape. In addition, it claimed a design patent on the rounded square icons. So the idea of a field of icons on a phone, that's something that Apple's also claiming with a very particular shape to the icons. In addition, some of the little movements you can make with your hands, they claimed patents on those as well. Samsung's claims tended to be more technological in a traditional sense about battery usage, energy use, things like that. Less about what a consumer might notice. But they went back and forth. So quite a number of different claims being made in this litigation. Now I just want to point out about the shape. Let's go back for a second. If you look at this shape, a rounded rectangle, or a rectangle with rounded corners, first of all, if I might grab something off here, the idea of a rectangle for content is not new. Right? So since Moses brought the tablets down, we have known that content is best put on a rectangle. Now it's true that this rectangle is a little bit different. There is not rounded corners and so forth, but otherwise it's basically the same idea. So there's nothing really new about this notion. Rounding the corners, that doesn't seem like a big innovation. And one of the issues at stake was, is that a useful feature or simply an ornamental feature? And that becomes important in the legal case, because something that's useful can't receive a design patent. Design patents are about designs. So the rounded corner rectangle is, I would argue, I don't want to say a ridiculous claim on the part of Apple, but it's not a claim that I support. I think Samsung was absolutely in the right to also feature a rounded cornered shape. And if you go back to some of their earlier phones, it's true that they didn't round off the corners on the Blackjack, but otherwise it's pretty much the same, and it comes out before the iPhone. So Apple's really kind of overreaching here. I put this up. If you're a fan of the American show The Office, you'll recognize this. This is the triangular iPad. Now you might say, why don't we have a triangular iPad in the marketplace? The answer is it's a terrible way to put content down. How do you feature things? So it's just to illustrate that there really are a very limited number of ways you can design a computer screen or a phone. And if you look at any number of the laptops around this room, you'll see they all are rounded cornered rectangles turned on their side. So this begins to suggest that maybe there's a functional feature to all of this. So as I noted, design patents cover non-functional ornamental features of a design. That's the idea. In most countries, it's referred to as industrial design. The US uses this term design patent. Those designs under American law have to exhibit some level of novelty. So simply saying, I'm going to take this and round off the corners is really not novel at all. However, design patents are increasingly important in the US economy. The US Patent and Trademark Office has granted over 400,000 of these design patents in its history, dating back to the founding of the United States. 2/3 of those are since the year 2000, so in the last 16 years. So there has been an explosion in design patents, and we will see more litigation like this around the world. Okay, I mentioned it's been over 100 years since the Supreme Court last heard a case about design patents. This is that case. And to give you a sense of how different the world economy was at that time, what was at stake in Gorham v. White in 1871 was the design of a fork and a spoon. Now, we would not consider that high technology today. Maybe in 1871 it was. But that was the last time they spoke to this issue. The Supreme Court said a couple of things that were important. One, why do we have patents in designs? Why is design important? And the answer is that, at least the court tells us, that we do it to give encouragement to the decorative arts, because we think, again, that absent that property right, producers will not invest in innovative designs that are good for consumers. We want to have a plethora of options for consumers, and we want good designs, so it incentivizes that. And then the question is, what's the test for deciding whether one design infringes another? And the answer is, if in the eye of an ordinary observer, meaning any one of us, giving such attention as a purchaser usually gives. In other words, imagine you're in the store and you're trying to buy two different phones. If the two designs seem the same, such that you might think that they're made by the same company, then that's infringement. So in other words, if you look at these two phones and you can't really tell which one is Samsung and which one is Apple, absent the trademark saying Samsung across the top, that's infringement. So it's kind of an ordinary person test. If the ordinary person is confused, there's a problem. That's the idea. Okay, so that's the legal basis. Second legal issue that comes up is trade dress. Now, design patents are time limited, 14 years. The other important feature about design patents, and this is why big corporations are very interested in design patents, they are what we would call a sort of strict liability property right, in the sense that if I hold a design patent and your company infringes it, it doesn't matter whether you did it accidentally, whether you intended to, whether you came to that design totally independently, you're still at fault. Trade dress is different. Trade dress is a variant of trademark. The idea of trade dress is that trade dress reflects here I'm quoting from the International Trademark Association. This isn't necessarily American law, but American law, in fact, most countries' law tracks this kind of definition because of the World Trade Organization, TRIPS agreement, and other trade agreements have harmonized most of these rules. Trade dress is the overall commercial image or look and feel of a product that identifies the source of the product. So when you see that product or the packaging, you recognize it as associated with a particular company. That can include the labeling, the packaging, the decor, the environment. So for example, a restaurant can have trade dress, protectable trade dress. If there are features of that restaurant, like a McDonald's or something like that, you walk in, you know right away where you are. Those are trade dress features. Size, shape, color, texture. The important point is to the extent that such elements are not functional. So again, these are not functional features. These are meant to be purely decorative features, purely decorative. So one of the things at stake in the struggle between Apple and Samsung is the balance between technological innovation but also design features that we as consumers really like. Trademark and trade dress are indefinite. They can last forever. So very important. Okay, so let me back up for a second. In the current litigation in the United States, the issue has really been whether Samsung has infringed on both the design patents that I mentioned as well as the trade dress of Apple phones. The lower court gave a very confusing ruling in which it said, yes, and Samsung infringed the design patents, but no, it did not infringe the trade dress because, and these are really very often exactly the same features, because it was functional in one context and non-functional in the other. It really didn't make any sense. And this is why it's going up to the Supreme Court. I think at a deeper issue, what we know is that the mobile phone industry is incredibly significant. There are over 3 billion mobile phone accounts in the world today, and that continues to grow. And so there's still enormous market share to be gained by these two giant companies, as well as many others that may crop up. So just south or west of us in China, there are quite innovative companies working on and selling very inexpensive, very powerful mobile phones, smartphones. So the smartphone industry is not going away, and this kind of litigation is not going away. Now, what's at stake here really is a question about the role of imitation, and this is where I began. Is it a problem that Samsung has imitated? And I'm going to put on the table, in my view, there's been some imitation going on by Samsung. Nonetheless, I have, from the beginning in this litigation, generally opposed the positions Apple has taken, and I've supported Samsung on the grounds that I think most of what Samsung has done has either been within the law or consumer protective and consumer friendly in the sense of providing more competition and more options in the marketplace. And this raises some larger questions. So is imitation necessarily bad for innovation? So when I began, I said there are some problems that we see or we anticipate when we allow a lot of imitation. We think innovators won't invest in innovation. Has Apple stopped investing in innovation in its iPhones because of Samsung's activities? No, I don't think so. And in fact, I think oftentimes what imitation does is spur a cycle of innovation and imitation that in the end produces better and cheaper products that we as consumers all benefit from. So rather than viewing imitation as something that's at odds with innovation, we have to recognize that there's a role for imitation. So for example, if you walk down the street right here in Seoul, you might find a coffee shop on one corner and another across the street. They both are selling coffee. They might even look somewhat similar. They might even have some of the same menu items. We wouldn't want to constrain that competition. We want to have that in a free market. We think that's healthy. So likewise, the smartphone market's a bit more complicated, but competition is an important good. So I note at the end, competition above all depends on similarities and differences in the marketplace. So when you buy a phone, you're deciding between not only Samsung and Apple, maybe other companies as well, but you're looking for functionality, for look and feel, maybe for status. There are various issues at stake. And a healthy competitive free market depends on that. Okay. Now, this video unfortunately can't play. But this is a young Steve Jobs. And what he says in this video, it's a famous one. If you Google this, you can just put in Steve Jobs and Picasso. what he notes in this is that Picasso said, and this is maybe apocryphal whether Picasso really said this, but Picasso said that, now I'm forgetting the first part, good artists borrow, great artists steal. And he says, we at Apple have been shameless about stealing great ideas from the beginning. Now, just take a look at the picture. You can see this is a young Steve Jobs. This is from when Apple was a tiny upstart, not the gigantic company that it is today. And he's upfront about the fact that ideas are out there, in a sense, to be stolen and to be improved on. And that's what companies do. That's what great artists do. That's what people do. We work on the basis of others. It's more powerful when it comes from him. But I'll summarize that. Okay, so let me move on because I don't want to run out of time. I want to turn to internet governance. Different issue, but some common ground. And I think an extremely important part of the global economy that's going to continue to grow. So the Apple versus Samsung debate is really about underlying property rights. Who owns what and what kind of ownership should we have? And again, I want to underscore free trade agreements like the TPP are heavily focused on intellectual property rights, securing them, strengthening them, and making them longer and stronger. Particularly in the United States, the US government devotes an enormous amount of attention, I would say a problematic amount of attention, to focusing on the enforcement of property rights and the strengthening of property rights and intellectual property around the world. We love to beat up on China in particular, but we're not limited to China. I think it's a mistaken strategy for various reasons. You can read my article in Foreign Affairs on this, but that's what we do. So it's about who owns underlying designs that are significant for consumers. When it comes to the internet and ICANN, the debate is a little bit different. It's not property rights per se, it's about who gets to govern and control domain names. So, as I said, pick any company, apple.com. That domain name is extremely valuable. It's a trademark. It's also a way for consumers and others to reach that site. And ICANN's role, so put ICANN/IANA. IANA is the assign names and numbers kind of function. ICANN controls the basic address book of the internet. So every time you get on your computer and you type something in and it gets to a website, it's because of what ICANN does. So that's the significance in a nutshell. Now, internet history in 2 minutes. I'm going to do this because people are not that familiar with internet history. Really quickly. How did the internet begin? And this is important to the story. It began with the U.S. Defense Department. And what today is known as DARPA, at the time was known as ARPA, Advanced Research Projects. So the ARPANET was the initial internet. The very first email sent from UCLA to Stanford in 1969. Many of the people in this room are not alive in 1969. That's how old email is. But the internet in 1969, there was no internet. There were only 4 servers at the time. 4 computers linked up. Was tiny. But that initial ARPANET grows over the years, through the 70s and into the 80s, into something very, very different. But it begins mostly as an academic enterprise. So John Postal was the initial person, part of a team at UCLA, a graduate student. I'm proud of this fact because I'm proud of UCLA and the role of the UC system in this story. He was a graduate student at UCLA, sadly defected to USC, our arch rival, but continued to play a key role in assigning domain names. But in the early days, domain names were something that universities had. So I remember in the early 90s, Mosaic, if anyone here remembers Mosaic, one of the first web browsers. I remember getting my first email account and so forth. That was early, and the only people who had them were academics and certain people in the US government. There was a .mil domain, top-level domain, .gov, and .edu, and a very small number of .com. That was it. And if you had an email account, you overwhelmingly were at an academic institution. That really begins to change in the 1990s. By the Clinton administration, the internet is increasingly seen as a commercial enterprise. Domain names are increasingly seen as important and valuable. The assignment of those domain names was free up until this point. It starts to cost a little bit. Not very much, but it costs a little bit. And already intellectual property is playing a role because people who are far-sighted were saying, wait a second, if I buy the domain name Samsung.com for $50, which is what it cost then, I might then be able to sell that to Samsung for 50,000 or maybe even 50 million. And of course, there were trademark disputes and so forth. So by the late 90s, the Clinton administration decides that something that it had launched way back under President Nixon, under Johnson. I'm trying to think who was president in 1969. I should know that.
Nixon
Thank you.
declared the Nixon Doctrine.
Yes.
1969.
Okay. See, this is why I need Professor Moon in all my talks. So something that had started in the Nixon administration, but the Clinton administration really had a very light footprint of the U.S. government. All the U.S. government had done was basically provide research funding initially and then kind of let it go. But the Clinton administration decides we need to get out of this business of having the naming and numbering done by some guy named John Postal out in Los Angeles. This is a big deal. This is the future of the global economy. And we need to really change that. And so what we need is an independent organization to run this process. And that led to the creation of ICANN. The Commerce Department issued a call for contracts, for proposals for a contract. A nonprofit organization was created, incorporated under California law, sitting in Los Angeles, that would play that role, and that was the Internet Corporation for Assigned Names and Numbers. Now, interesting question. I'm going to jump down to this bullet point. Who really owns this function? So, from 1998 till today, there is literally a contract that the Commerce Department of the U.S. government hands out to ICANN that gives them the ability to decide how the address book works, who gets what domain, and so forth. The question is, does the U.S. government actually have the power to do that? What gives them that power? It's extremely unclear whether they actually have that property right or not. So simultaneously as this is going on, there are all these attempts to multilateralize the internet. The internet starts off as an entirely American invention, and it's almost entirely a US thing. Slowly, foreign universities get involved in the 70s and 80s. As it becomes more commercial, foreign companies get involved. But even by the 90s, the internet is still, if you looked at user base, overwhelmingly American. Today, not at all. And in fact, from 2000 on, the internet is predominantly not a US entity. And the vast majority of users today are right here in Asia. There are many more internet users in China than there are in the United States. So the internet is no longer an American thing, though of course it is created and invented in the United States. So the fact that the US government has this power over ICANN stemming from this contract is bothersome to a lot of countries around the world, China being one of the most important opponents of this. So there's all these attempts to multilateralize this effort. So the World Summit on the Information Society, the World Conference on Information Technology, Net Mundial, which took place in Brazil, and of course the International Telecommunications Union. All of these different organizations and UN-sponsored events occur as there's an attempt to say, wait a second, the US should not own this process. This should be a global process. So just to put it in perspective, here's ICANN sitting in an office building in Los Angeles. Here's the ITU in Geneva. The ITU for many years really wanted to control this process and wanted to have a stronger governmental imprint on it. The US resists that in favor of what it preferred and what ICANN calls multi-stakeholder governance. The idea being having a whole array of users, producers, engineers. I know you can't read this. It's mostly a bunch of acronyms that are confusing. But the notion is, rather than a traditional state-to-state process like we see in most contexts in the world of foreign affairs, what we have here is a stakeholder process with people from all walks, private and public, participating. Okay, so the issue, what's happening right now, and I'll close with this. About a year ago, the US government announced it was going to cease contracting with ICANN and simply hand over control to ICANN altogether. That's occurring right now. That process is underway. It's facing some significant opposition. So I already noted, is the US really in control at the moment? Does it really have the power to issue that contract? And if it stops issuing that contract, what does that mean? That's a legal question that I would say no one has a good answer to. But the government of the United States acts as if it has that control. In Congress, we have seen, especially coming out of the Republican Party, significant opposition to this. So congressional Republicans have liken this to the handover of the Panama Canal. So if you go back to the 70s, President Carter handed back the canal to the Panamanians. Republicans were deeply opposed on the grounds that this was an American invention put together, built, created, so they said, and it was a giveaway to give it back to Panama. Likewise, they see the internet governance function in the same way. What's really at stake for the global economy is this idea of multi-stakeholder versus multilateral governance. Should we have a state-to-state process around the internet? Or should we make sure that it is a participatory process that all of us independently can play a role in if we organize ourselves, whether we're companies, users, engineers, technologists, whatever it might be. Now, politically, why does this matter? It matters because for many countries in the world, and I'll take China as a paradigmatic example, the internet is an important form of social control. It is not a free and open internet. If you've been to China, and I'm sure many of you have, you know there are certain sites that, absent using special techniques, you cannot get to. And those sites include Facebook, Google, New York Times, etc. These are not fringe sites. As well as if you try to search for Tiananmen or any number of other things, you'll get nothing. So the internet, and that's not unique to China. China is just the most famous example of that. Iran does a very similar thing. Many authoritarian governments control the internet and censor it heavily and believe the internet is a powerful tool of political and social control. The position in the United States is different. The US government does not interfere in that way. Of course, there is spying that takes place. And the role of the NSA and the revelations that came out of Edward Snowden are important to the story. I'm happy to talk about that in the Q&A. But the US has strongly favored an open and free internet. And so the battle between multi-stakeholder and multilateral governance is really about state control versus popular control, but also about the degree of censorship that's permissible or allowable. So let me conclude with two things. So virtues of openness and perils of control. When we think about, let's go back to Apple and Samsung. When we think about Apple and Samsung, we're talking about a battle over who owns what. And intellectual property is about ownership. It's about regulating a free market to make sure that certain things cannot be said or done. So if I copyright a book, you cannot copy that book without my permission. So there are certain things you cannot do. And that's, again, intended to have a positive, innovative, creativity-forcing function. One of the points I made about the Apple and Samsung dispute is that Samsung's imitation of Apple was certainly imitation, but in the long run, it was positive for all of us as consumers. And so the openness and the ability to copy freely can have very positive effects in a world economy as dynamic as the one we're in today. Likewise, when you control too much, as we see with efforts by China with regard to the internet, as well as other authoritarian governments, that itself brings a whole host of problems. So this balance between allowing openness, but maybe then possibly killing the goose that lays the golden egg, destroying the incentive to create and innovate in new ways, that itself can be problematic. So the key is to find a balance, and we have to find the proper balance. So whether it's in TPP, whether it's in future negotiations of the World Trade Organization agreements, the Doha round, which is somewhat moribund right now, but maybe revived, other trade agreements we might imagine, finding that right balance will be incredibly important. So I hope we'll see that done. I'm just going to close with saying if you're interested in some of these issues, this is my book in Korean. It is available here in Korea. I talk about many of these topics, not, of course not ICANN specifically, and Apple and Samsung come later, but many of these issues around imitation and innovation are covered here. So take a look if you want. Thank you very much.
Could you